Okay, so we're still on prohibited terms. We haven't got very far, have we? You can't have a term exempting the landlord from any liability for an action, omission by the landlord, the landlord's agent, or any person acting on behalf of the landlord. That if the tenant breaches the agreement, the tenant is liable to pay for all or part of the remaining rent under the agreement. Now, don't be confused with the right to pick up compensation, as we do with under Section 78 now. You can, if you go into a situation of mitigating loss, then you can claim the differences, rent to the day of, all of that is still there, but you can't have a clause in there that says, well, if you walk out, you're liable for the rent to the end of the fixed term. And some people do have those in there, okay? The next one, the one that I'm proud of, is that if there is an animal permitted in the property, then you can charge for cleaning, carpet cleaning, etc. It says that the residential tenancy agreement may include a term that requires carpet to be professionally cleaned, or requires the tenant to pay such cost of cleaning at the end of the tenancy if the landlord permits the tenant to keep an animal on the residential premises. Now, I wrote that clause probably 10 to 12 years ago, and I was told by members of the tribunal, if it comes before me, I'll strike it out. And I said, well, I'll see you in the Supreme Court, because this is a contract between a landlord and the tenant for consent to have an animal. Nothing to do with the tenancy itself. Because you've got a house with bedroom, with a backyard, doesn't necessarily allow the occupant to have an animal. So they want to have an animal, they make an arrangement, and this fell within that. And to my mind, they picked up on that as being sensible. That you have to make sure that the next tenant is not affected by what's left behind by the animal. So you can have fur and fleas and everything else associated with it. So making good the damage and cleaning the carpet is now a permissible term if there is an animal involved. So I'm fairly pleased that we got that one. It's a tick.
Yeah.
Not the one that sticks to you. So there you go, prohibited terms. And along with all of those, you've got that situation that, as I said earlier, you cannot have anything in the agreement that's in any way in conflict with the current legislation. But that's always been the case, and we should need to live with that. Condition reports are the next thing. Very interesting discussions going on about condition reports right now. One of the things that they have guaranteed that they're going to do, they're going to eliminate coppers in the laundry. You know, have you looked at yours and seen that there's a copper? We've had young people say, what's a copper? It's not somebody that rides a bike and wears a helmet, is it? No, it's a copper.
How will you get the whites clean, mate?
I actually saw one of those on television last night, and also a mangle.
No, that one loses me.
Yeah. Anybody old enough to remember a mangle? Yes. Well, we don't have to mention those on the condition report either. But what the important thing with condition reports, and they're going to be in a slightly different format, I think the tendency is moving towards the landscape type print rather than the portrait print, because those that use the portrait one, there's really no room to do an accurate condition report. So the one that's printed in landscape form is probably going to be the one that we're hoping that we can say, well, that's the style that is acceptable as far as the legislation. But we haven't got that far yet, but it's on the table, isn't it?
Yes, it is.
Yeah. So I think that's something that would be a bonus to us all, to have a consistent and clear condition report. Obviously, if you've been involved in any sort of tribunal work, that accuracy of that condition report, both at the beginning and the end, is the key to the whole thing. So, you know, I can't emphasise that enough. We're not here to be doing fundamental property management, but it's there. Okay, the premises themselves. In the current legislation, there's a requirement for the premises to be left in good condition or presented in good condition. It has the words in there, having regard to the age, the rent payable for and the prospective life of the premises. That's no longer there, it's gone. Can't understand why, but it's gone. The definition under that same section, if you've read, you could recall your act, talked about the residential premises includes everything provided with the premises, whether under the residential tenancy agreement or not, for the use of the tenant. That's at the bottom of that section on the landlord's responsibility. That's not there either. And you've got a new obligation under section 52, and I'm not terribly excited about this either, but again it comes back to what you're going to have to investigate. Virtually the clause itself starts with the landlord must provide residential premises in a reasonable state of cleanliness and fit for habitation by the tenant. That was implied in the 87 bill. The landlord's not to interfere with the gas, electricity or water or telecommunication services to the premises. But the interesting one is the landlord must comply with the landlord's statutory obligations relating to health and safety of the residential premises. That's brand new. I mean, it's a buzzword, I suppose, but you're going to now have to find out what are the individual statutory requirements of the landlord for all of your properties. There. Such obligations, it says, a briefing note, it says, includes the obligations relating to swimming pools under the Swimming Pools Act of 1992. But there would be numerous other pieces of legislation that you would need to now be able to say the premises comply with. How far you go with this, I'm not sure. But you would obviously need to make your landlords aware of their obligations. And if the landlord is aware of anything that that you may not be aware of, he must declare it and in turn fix it.
Can you give us a couple of examples, perhaps?
Well, the only one that I've got here is the Pools Act.
I'm thinking Dividing Fences Act, perhaps.
No, I don't think so. No, it's to do with health and safety. So I don't think a dividing fence is health and safety. Is it?
What about balconies, stairs, heights of railings,
Yeah.
window
Yeah. Things though, like the compliance, and this is one that nobody's ever been able to answer as satisfactory from my point of view, is with upgrading glass to the Australian standard. Now, you well know if you're handling something to do with strata properties, if somebody breaks a sliding door, it can only be replaced with safety glass, but there is no obligation to go around and change all sliding doors. So you can have the existing glass until it actually gets broken.